Let's be honest, we've all heard the HOA horror stories, right? That little disagreement over lawn ornaments that just explodes into a full-on war. Well, today, we are going deep inside one of those battles. This is a real-life case of a homeowner versus her Homeowners Association, and we're going to dig right into the court documents to see what really happens when things go completely off the rails. So, imagine this. You are at your absolute wit's end with your HOA. You've sent the emails, you've made the phone calls, nothing's working. And you start thinking about doing the one thing you never thought you'd do, suing them. But what does that actually look like? What happens next? Well, this case is going to show us step by step. Okay, so here's our roadmap for today. First, we'll meet the people involved. Then we'll get into the two biggest fights, the dying trees and a dispute over a door. After that, a quick lightning round on some other complaints, and then the moment we've all been waiting for, the judge's final decision. Let's dive in. Our story begins on January 5th, 2007. In one corner, we have the petitioner, Homeowners Sieglinde Martin, and in the other corner, the respondent, the Bells 26 Homeowners Association. The starting gun for this whole thing was a single legal petition where Martin accused her HOA of not following its own rules. And from there, the drama really takes off. So the first claim is filed over a very, very familiar battleground for anyone who's lived in an HOA. The landscaping. I mean, this is where so many of these wars begin, right? In the dirt and the bushes of the common areas. Okay, so here's how it breaks down. The homeowner, she's pointing to what she sees as total chaos. Dead grass, messy hedges, and specifically 12 cypress trees that she herself planted that she says are dying of thirst. Now, the HOA's response is interesting. They don't actually deny it. They basically say, look, we know, we're trying. They said they'd already fired 2 different landscapers and were having a really hard time finding a good one. And this right here is where everything changes. Because the judge wasn't really looking at the state of the lawn. The judge was looking at the HOA's rulebook, the declaration. And look at this language. It doesn't say the HOA has to make the grounds look perfect. It says it has to use and expend the assessments to maintain them. That is a small but absolutely crucial difference. So the judge lands a knockout punch on that first claim. The ruling, no violation. Why? Because the HOA was spending the money, they were trying to hire people, their legal duty wasn't to guarantee a perfect lawn, it was just to make a reasonable effort. That's a tough pill to swallow for the homeowner for sure, but a huge legal win for the HOA. But the fight is far from over. We're moving from the common grounds right up to the homeowner's front door. The next battle is all about a paint job. And just like before, we have 2 totally different stories. The homeowner says the paint job was sloppy, and then, when she decided to rip out some old carpet to put in new tile, it exposed a bare spot that the HOA never came back to paint. But the HOA says, whoa, hold on. They argue the paint job was standard for all the units, and that she pulled up that carpet after their painter had already finished the job and gone home. So whose problem is it? And again, it all comes down to the fine print of the rules. The judge pointed out that the HOA's governing documents gave them the option to make a repair, but it didn't create an obligation. It's kind of like if your friend says they can help you move, that doesn't mean they legally have to show up on Saturday morning. It's a choice. And in this case, the HOA chose not to fix it. And boom, just like that, the second claim goes down in flames. The judge ruled that because the homeowner's own renovation project created the unpainted spot, it became her responsibility to fix it. It's kind of a legal version of you break it, you buy it. All right, we've dealt with the 2 big ones, but the homeowner wasn't done yet. She had a few other complaints about how the HOA was being run. So now we're heading into a quick lightning round where we'll see how the judge handled these one by one. Okay, so here are the next 3 claims. First, that the HOA was holding meetings without giving proper notice. Second, that someone who didn't even own a property was put on the board, which is a big no-no. And third, that the HOA was letting some people build structures that were creeping onto common property. So, what about those improper meetings? Well, the judge's ruling on this was fast and final. There was 0 evidence presented to back it up, so claim dismissed. Now, this next one is interesting. The judge actually agreed with the homeowner here. Yep, the HOA did violate the rules by putting a non-owner on the board. But, and this is a big but, that person had already resigned from the board by the time the case was heard. So the judge called the issue moot. That's just a legal term for saying, well, the problem's already been fixed, so there's nothing for me to do here. And for the final claim in our lightning round, the illegal encroachments, you can probably guess the theme by now. The judge ruled there was just not enough evidence to prove it was happening. So, after all of that, the arguments about the dead trees, the fight over the front door, the complaints about how the board was running things, it all comes down to this one moment, the final call from the judge. And the final tally? The total number of violations that the judge found required any kind of court action was a big fat 0. The homeowner's entire petition was denied. So what's the big lesson we can pull from all this? I think this case perfectly illustrates a really important legal idea. An HOA's job isn't to make every single resident happy all the time. Their actual legal duty, according to this ruling, is to take the money they collect and make a reasonable effort to maintain the community. That's a simple distinction, but it makes all the difference. And that leaves us with a pretty big question to think about, doesn't it? For your own community where you live, is trying your best a good enough standard? It's definitely something to consider the next time an issue pops up in your neighborhood. Thanks so much for joining me for this explainer.